Welcome to Legal Awareness web series. I have received many requests and emails for starting Legal Awareness web series in English. Civil services, judicial services aspirants have been writing to me for long to have this kind of conversation with you in English. Since my teaching career started with criminal law teaching, I thought it appropriate that even this web series should start with criminal law conversation. In fact, my first encounter with legal research was through strict liability crimes, which means that we punish people without mens rea. Now, today's topic is hotly debated in media because our Home Minister has said that he has set up two committees to look at the revision of Indian Penal Code. So let us address this question: does Indian Penal Code really need any revision? And if it really needs revision, what are the provisions which must be reviewed and must be revised and revisited? So first of all, we should understand why criminal law is important. Nobody can doubt the importance of criminal law because criminal law's promise as an instrument of safety is matched only by its power to destroy. Many of us don't appreciate this. Criminal law can also destroy. Criminal law is indeed the most direct expression of the relationship between a state and its citizens. As you know, in criminal law, it is the state which prosecutes. In no other branch of law, more is at stake for the individual and for the community as in criminal law. And therefore, when we talk of criminal law, we must always look at how it will impact individuals, how it would impact the larger society. This is not for the first time that a call has been given for the revision of IPC. I remember in 2016, our former president, Pranab Mukherjee, has also said that IPC needs a thorough revision to meet the needs of the 21st century. And therefore, I would support Amit Shahji's call for revision of IPC. But we need to know why we want to undertake a revision. Do we want to improve IPC, make it more progressive, or do we want to make it more regressive? If it is going to become more regressive, it is not good for the country. Why? Already, in terms of criminal justice system, particularly on the question of death penalty, India is in the company of Sudan, Saudi Arabia, Iran, Afghanistan. As a citizen, I don't want my country to be in the company of these states. I would like to see them in the company of Scandinavian countries. Even America on criminal justice system is not a very progressive nation. So there has been a call of revision of IPC, but we have not really appreciated that why we want to amend IPC and undertake its revision. First of all, we must understand when IPC came in, it was the most progressive code in the world. And that is why it is being followed in the entire Commonwealth. And we have undertaken some 75 amendments to IPC. Ad hoc amendments, reactionary amendments. So 2013 we had the Delhi gang rape case, we got this 2013 Criminal Law Amendment Act. In 1971, 42nd report of the Law Commission has recommended a thorough revision of IPC. The bill was introduced, but it lapsed because Lok Sabha was dissolved. In 1978, again a bill was introduced, but it also lapsed because of the dissolution of Lok Sabha. When IPC came in, what kind of criminal justice system it replaced? It replaced Islamic criminal law. And as I said, that it was a progressive legislation because it was not based on deterrence. It was not based on the concept of a life for life and a limb for a limb. I get surprised to see people in India today talking of Islamic punishments. And many a times they say that we should have a higher rate of conviction. Higher rate of conviction is not a measure of success of a criminal justice system. In fact, punishments do not deter. It is not the intensity of the punishment which has a deterrent effect. It is the certainty of the punishment which has a deterrent effect. Now, IPC is to be appreciated and was appreciated as a state-of-art code. In fact, it was the first codification of criminal law. We must also thank the British that they gave better laws to us than were the laws in their mother country. So they did not have a code, but they gave us a code. Lavishly paying compliments to T.B. Macaulay's masterpiece called Indian Penal Code, James Stephen had remarked that the Indian Penal Code is to the English criminal law what a manufactured article ready for use is to the materials out of which it is made. It is to the French Penal Code, and I may add to the North German Code of 1871, what a finished picture is to a sketch. It is far simpler and much better expressed than Livingstone's code, and its practical success has been complete. Macaulay had himself favored regular revision of IPC. He said whenever gaps or ambiguities are found and experienced, we must amend it. Therefore, Macaulay cannot be blamed for IPC. We did not amend it. What kind of amendments we undertook? Increase punishment of rape, increase punishment of kidnapping, increase this punishment, that punishment. We have not yet amended substantive definitions given in IPC. Can we give a different definition of theft or assault or grievous hurt? That is the question. Now, James Stephen's metaphor that IPC as a manufactured article, if we accept it, then I have to say that it has not even been properly serviced, let alone remodeled, since leaving the codifier's desk. And that's why Amit Shahji's call for revision of IPC. And that's why my endorsement of his call. I agree that there cannot be any denial of a fact that the philosophical stand and the fundamental principles of Macaulay's code, as Home Minister said, were the product of particular time, culture, and imperialist policy of empire. So, there is a valid point that some of the concepts underlying IPC are either problematic or have become obsolete. But we need to identify in what areas of IPC, in respect of which crimes of IPC, we want to bring in reforms. Now, just to discuss few things about reforms, let me at the very outset here say many people in India and many politicians in India believe that if we increase punishments, then change criminal justice policy, then we will be able to reduce the incidence of crime. There is absolutely no relationship between criminal justice system's policy and incidence of crime. What we need to do is really to change the outlook in the matter of punishments and shift our emphasis from the offense to offender. We must realize that the criminal justice system is not about crimes, it is about criminal. Why criminal is to be protected in a criminal justice system? Because in a criminal justice system, a little man, an accused, is pitted against the might of the state. State may abuse that power, and therefore you have an idea of presumption of innocence. That's why you have the concept that the criminal statutes are to be strictly construed. That's why you have a concept that it is for the state to prove beyond any shadow of doubt what crime you have committed. We need to really understand this, that the criminal law should move from crime to criminal and should also take into account the victim. A whole field of victimology today has developed, but in the name of victim's right, we cannot be taking away the right of the accused. Now, few offenses I want to straight away talk about which need a revision. One is the whole question of sedition. Now, in a democratic country, how can you have this kind of offense which even Macaulay did not include in 1860? Sedition was included in 1898, and the reason was that Deoband has given a fatwa asking Muslims to declare jihad against the British. Sardar Patel, BJP government respects Sardar Patel so much, they should also follow Sardar Patel. Sardar Patel himself opposed sedition as a ground of restricting freedom of speech under Article 19. Supreme Court judgments also say, unless there is some violence coupled with some statement, it is not sedition. I think offense of sedition should go. Similarly, many religious people may disagree with me, but a modern liberal society like ours should not punish blasphemy. Therefore, Section 295A, which again was inserted in 1927, should go. Criminal conspiracy was made substantive offense in 1930. There are doubts about the need to continue this type of conspiracy, which punishes people on having mere agreement without any overt act following that agreement. Just because there was some agreement, let us commit this crime, we punish people. This is against modern notions of criminal justice system. The crime of conspiracy, Russell has said, affords support for any who advances the proposition that criminal law is an instrument of government. Justice Fitzgerald observed, law of conspiracy is a branch of our jurisprudence to be narrowly watched, to be jealously guarded, and never to be pressed beyond its true limit. We have seen how law of criminal conspiracy was used in Indira Gandhi assassination case against Kehar Singh. And when Kehar Singh was hanged, newspapers had said it is a judicial murder. Similarly, I believe that Section 149, where you have a principle of constructive liability, it is taken to undue harsh lengths. Just because somebody was present in an unlawful assembly, we punish them. I think it is not right. We should have a relook at it. The whole distinction of culpable homicide and murder was criticized even by Stephen as the weakest part of the code. As definitions are obscure, culpable homicide is first defined, but homicide is not defined at all. Indeed, culpable homicide not amounting to murder and culpable homicide amounting to murder are so confusing that many students of law find it difficult to distinguish them. Sexual offenses need a revision. Of course, we are grateful to Supreme Court that 377 is now gone, adultery is now gone, but marital rape is still an offense. Marital rape is still not an offense. And if somebody's wife is more than 15 years of age, it is not a crime. So I feel that there is a need that we relook at Indian Penal Code, bring it in consonance with modern liberal notions. Let us have a revision of Penal Code so that Penal Code fits into our liberty model of governance, citizen-centric model of governance. Let it be a code for citizens rather than for the subjects. And I must say that Macaulay himself used to say that India cannot have a free government. She can have the next best thing, which means firm and imperial despotism. If through reforms in Indian Penal Code we want to bring in despotism, it is bad. If we want to bring in liberty, if we want to make it a progressive code closer to Scandinavian countries' criminal justice system, I think this is a good initiative and it must be welcomed. If you like Legal Awareness web series, I would request you to subscribe to our channel, like us on Facebook and Twitter, and give us your suggestions. I would read your comments and respond to them.